Guilty.
Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
Kaylee Goncalves.
Guilty.
Xana Kernodle, pardon me.
Guilty.
Ethan Chapin.
Guilty.
There's always some degree of crud in there.
Mr. Myers, why in the hell would Bryan take this plea?
Bryan Kohberger took the plea, but there are a lot of questions about what actually happened in the courtroom and also what happens next. Kelsey's with me today on this issue of About the Law. I'm Andrew Myers. This is About the Law. Why did Bryan Kohberger even take this plea? Joining me in this episode of About the Law, Kelsey, good morning. How are you?
Good morning. I'm good. How are you?
I'm not bad. I was just really shocked that he even took the plea. And then I listened to the hearing where he took the plea, and I'm even more shocked. What were your initial feelings about the whole thing?
I was shocked. I had a feeling he was going to take the plea, but I don't believe he should have taken the plea. I feel like there's still some things wrong with it, and people are left without answers.
I think a lot of people agree with you, but it is a plea. It is final. The court accepted it. He hasn't been sentenced, as you know. That'll happen in a couple of weeks on July 23rd. But people had a lot of questions about this. So without any further ado, why don't we take a look at it?
I understand the state and the defense have reached a plea agreement in this case.
That's Judge Hippler, of course, and the judge at the beginning of the hearing had some comments of his own. You know, he was angry at the public that, people have been writing him letters, and he said, we don't have time. A, we don't have time for this, and B, it's improper to, write a letter to the judge, and C, he never takes public sentiment into account, as well he should not. But, why would anybody write a letter to the judge? That's crazy.
For the record, I have a written plea agreement which indicates, in sum, the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35.
So that's a big thing. He waives his right to appeal. He'll never, at least if future courts, go along with this, he's waiving his right to appeal. And that's a big thing. It's a big thing that, okay, you take a plea and then, you reserve the right a few years later to say, hey, wait a minute. No, not here.
But who's to say, 10 years from now that could change?
I have heard other attorneys split on that. I've heard other attorneys say, yep, this is a done deal. It's ironclad. There can't ever be an appeal. But call me a skeptic. But, over the years, just observing things that happen, you know what? Who's to say what would happen in 10 years? Maybe the legislators somehow along the line will pass some kind of a law. Maybe a new governor will come in. Maybe. There's a lot of maybes. I highly doubt it. Charles Manson came up to the parole board every few years and they just said no. So, you know what? He is waiving his right to appeal. So, we're not going to see years and years and years and years of appeals like we often do in some other cases.
This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right.
This would go a lot faster if we edited out all the paper shuffling.
I know.
Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
Isn't that interesting? Because only a week or two earlier than that, Ms. Taylor was saying that there was discovery that she still needed to get, and there was still some of that 68 terabytes of discovery she still hadn't gone through. So this is an answer she has to give. She has to say, yeah, I've got all the information and I'm satisfied. But it is a change of position in only a couple of weeks.
But she seemed a little hesitant with that answer.
You think so?
Yeah.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right.
And so we hear from him for the first time in a long, long, long time. I mean, when he was arraigned, those many years ago, he stood silent, and his attorney said that. So this is the first time we've heard from him for a long time.
Thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. And Mr. Kohberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
What needs to be established by a court, and what this is called a colloquy, when the judge questions the suspect, or now the defendant. Now he's admitting it, so I guess we don't even have to use those terms anymore, but it's very important for the court to determine that this was his free, voluntary act, that it was acting, with full, recognition of his senses, that he knew what he was doing, and so this is a requirement for any court at a plea hearing. And it takes on additional gravitas in this case when there have been so many questions.
All right. I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count one, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first degree. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts.
Isn't that something that, in addition to the life sentence, they also give him a $50,000 fine? I mean, this guy's destitute. He has a court-appointed staff of attorneys, and who knows if the state will ever see a penny of the $50,000 on each count.
In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose
How's he going to pay for those samples?
any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
So he can never run for public office. Hey, Mayor Curley in Boston won re-election from a jail cell. So.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
What do you think the parents are thinking? I mean, they're finally hearing the voice of this guy. The parents have been, some of them have been outspoken. They've been angry. Obviously, they've had feelings. Obviously. What do you think the parents are thinking now that they hear this guy's voice for the first time, really, in court?
I think they're probably feeling multiple different emotions. And I know some of the families agree with the plea. Some of them don't agree with the plea because they don't get answers. Some are fine with not having the answers. But I think that they're just having multiple different feelings at once.
But what do you think that they think, now that they're hearing his voice? He's only saying yes or no, but what must go through their minds when they hear that voice?
They're probably, because they know like their children were hearing that voice. So that's probably the last voice that they heard.
Creepy, very creepy.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
Yeah, there's so many motions filed in this case. One day I came in, in the morning that we were going to do a podcast on this case, and overnight, at least to me, 21 or 23 motions, I forget, had been filed. And so I'm sitting here, how am I ever going to read through these and do a podcast on this? I mean, and that was just one day. I think those were early motions to suppress evidence. And then, of course, there were all those motions that were filed in an attempt to remove the possibility of the death sentence in this case. So I don't know what motions were left. I'm sure someone could sit down and think of them. If you think of any additional motions, let us know down in the comment section. Let me also point out that if you're getting anything out of this, our commentary and our podcast, be sure to like and subscribe.
Do you think that them accepting the plea deal was just Kohberger and his attorney giving up?
I don't know. I mean, there might be an element of that. I mean, obviously, I would think that nobody would want to be facing the death penalty. One thought that I had is that how could you go to sleep at night thinking that having an image of going before a firing squad? Idaho implemented the firing squad because previously they had the DP by chemicals, and the chemical companies wouldn't sell them to them anymore. And so actually in early 2023, Idaho's legislature implemented the firing squad. So can you imagine going to bed every night thinking that, someday you'll have, I don't know how many, 6 or 8 gunmen pointing guns at you? I mean, I'm thinking that might be one reason. I don't know. I'm not in Mr. Kohberger's head. I certainly hope it's not because the attorney, felt she was unprepared for trial, because that's way over the line of being unethical. So who knows? It's hard to believe for me. All these years I've been sitting here saying, I don't know. I've been called a guilter. I've been called a pro-burger. I've been called all these different names only because as an attorney, I want to, maintain the presumption of innocence. And I've said, I would maintain the presumption of innocence until and unless he's found guilty. Well, he's admitting guilt. And I think a lot of people have a lot of questions.
I think that they exhausted all their options and the plea deal was the last thing that they could do.
I guess so.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Why was he so quick to accept the plea deal and knowing that he was never going to be able to appeal, he was so quick to accept it?
That is a difficult question. He's probably been thinking this all along. I mean, if he is in fact guilty, if he is in fact the perpetrator that did what he's accused of doing on the night of November 13th, 2022, I'm thinking that he has come to the realization that his attorney and his staff of attorneys, there are 3 of them sitting there, have done everything they can possibly do. And the only other thought I'm having is that it couldn't have been a snap decision. This was something that was thought out. You don't just make a snap decision that, okay, I'll surrender, throw up the white flag, and agree to spend the rest of my life in jail. I mean, you can't agree to do that without a good deal of perspective, I wouldn't think. So that's what my guess is. Obviously, I'm not inside of his head. I'm not inside of Ann Taylor's head. The thing that a lot of people don't understand is that, Ann Taylor stood beside him on several hearings and put her arm on his shoulder and said, I believe in his innocence. Oops.
But do you believe that innocent people can plead guilty?
In smaller cases, yes. In smaller cases where, they just don't want to undergo the time, maybe expense, and the grueling nature of a trial. Yeah, it happens in smaller cases, I think, all the time, just to get it disposed of, to not have to go through it all. But in a case like this, I can't imagine that happening in a big case like this, especially, where this comes 2.5 years after Mr. Kohberger was arrested back in Pennsylvania. So it's hard to think that it was a snap decision.
Have you had enough time to decide whether or not to plead guilty?
Yes.
You pleaded.
See, that was a good question you asked. That was a good question, and we didn't even have a script laid out for the way this was going to go.
Guilty freely and voluntarily.
Yes.
Given
That's
your
the big
choices,
question.
do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
I think a lot of people don't understand, that a defendant who is pleading guilty does, in fact, have to acknowledge all of these things. You have to acknowledge that you have the right under the United States Constitution and likely the Idaho State Constitution too. The right to confront witnesses, the right to ask questions, the right to a presumption of innocence. I mean, out here in the YouTubosphere, people say, oh, he's guilty, he did it. Or they say, oh, he's innocent, he didn't do it. But in a court of law, you have a right to go in, and the jury must presume that you're innocent until such time as enough evidence is presented to prove that you're guilty beyond all reasonable doubt. And I think a lot of people don't understand that to plead guilty is such as going in and say, yeah, okay. No, you have to understand that you're waiving all of those rights. You're waiving your right to a trial. And so it's hard to think, to answer the question you had before, it's hard to think that, 10 years from now, he'll say, oh, well, I didn't realize what I was doing. You know what I'm saying?
Yeah.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence, Local County, Idaho, U 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, Kaylee Goncalves, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
A lot of people were very disappointed by that because he's just, basically pleading out to the basic elements of the charge. Every statute, every charge is broken down into elements. And the judge just said, do you agree to that? Yes. And so a lot of people are really not happy that they didn't get into the details of the thing, but that's just how it is. That's the way it goes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
Let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of.
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, Madison Mogen, a human being?
Yes.
Did you honor about that same date in Moscow, Idaho, Kaylee Goncalves, a human being?
Yes.
And did you?
Yikes. It's a lot to hear this from me. I mean, it's just a lot to hear this from me after all of these hearings, all of these motions, all of the discussions. I mean, there have been so many motions filed. There have been so many hearings in this case. And just for him to sit there and say, yes.
You do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, Xana Kernodle, a human being?
The least the judge could do is get the name right. He got it right the first time, but the second and third times, to me, it's cringeworthy.
Yes.
And did you do that willfully, unlawfully, deliberately with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you, Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor.
So anytime there's a plea agreement, there's just a need to provide a factual statement, a factual basis. Some places call it an admission to sufficient facts or a reading of facts. And that's basically what he's doing. Unfortunately, there were very few new details. There were a couple, but it really tracked the probable cause affidavit for the most part.
Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents.
Yeah, there were just a couple of minor things. There were a
This
couple
is
of minor
not-
things. I would ask our viewers, I would ask our commenters to comment down below what's new, what's different. A lot of it was the same, but there were a couple of little things in here that were a little bit different from the probable cause affidavit. So I would ask our viewers to tell us what they are.
The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing in his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife sheath.
Okay, the guy's a criminology student going for his PhD, and he goes on Amazon.com and buys the knife. I mean, really?
And he bought it like 8 months in advance too.
Yeah. What did you say before when you said you could have bought it at the flea market?
Yeah, he could have just bought it at the flea market. Couldn't trace it.
Cash.
And sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho.
Yeah, but what does that have to do with it, really? I mean, apparently that cell tower had a pretty large reach, several miles. So, lots of people drive by there, and a lot of people drive around in the middle of the night. I had a job really early in my life where I worked until about 1 o'clock in the morning. And, so what? He pinged a cell tower.
I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times.
No contact with the home is proven, and no contact with the residents of the home is proven. That's crazy. I don't even know how that's relevant. I mean, I guess it's a circumstantial case, and they have to, reach as far as they can for every possible piece of evidence. But I mean, I don't know. That's so what he drove around. I've talked to residents in that area, and people from Pullman, Washington often drive over to Moscow, Idaho, because it's kind of a cool college town. They have coffee shops. The Walmart is open more hours. There's a lot of reasons to drive over there. But all right, I'll accept that it's a circumstantial case, and they have to put as much in as possible. But he just stated in open court there was no contact with the residents or with the home.
In the interim, on August 22nd of 2022, Lake Tahoe County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until.
There's a little bit of feedback in this, and at first I thought it was my computer because I was doing two things at the same time and I turned everything else off. But no, it's actually in the court's audio that there's some feedback or somebody else's computer is doing something that's in this, but it goes away in a few minutes. So bear with it. It's on the original that we got out of the court. And if you listen to the hearing live, it was in there. It was weird, but there it is.
Approximately 4:48 a.m. on Sunday,
Hear that?
Yeah.
I guess it's some feedback.
the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow, that would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood.
You know, there's a lot of
Starting around
Elantras in that area. It's a
3:30 or so
white
in the morning.
Elantra. You know what? I think someone said there were something like 22,000 Hyundai Elantras in that area. And you know what? Since the beginning of this case, and they talked about the Elantra, I never really noticed it on the road, but just driving around our area, going shopping, going to court, whatever, I've noticed a ton of Elantra. It's a popular car.
It's a very popular car.
You know, I don't have one. I have another type of a popular car, which I see, but now I see Hyundai Elantras all over the place. And so unless they can really tag it to him, you know, or show him inside, I don't buy this stuff about, oh, well, it didn't have a front license plate, because I think something like 29 different states don't require a front license plate, one of them being Pennsylvania, where I grew up. And yes, from then until now, they still only have one license plate. But I really don't buy all the significance of all of that. I think this presentation could have been shortened quite a bit, because we're not getting real details. We're not getting, you know, the type of particular information about what happened that night. And a lot of people, including the families, some of them, not all of them, you know, are really let down by this. I mean, he's just pretty much summarizing largely what was in the PCA, and we're not really learning a whole lot about what really happened that night.
I think he's just reaching for evidence and details just to have something to fill the space.
Yeah, just to fill the space and, you know, say, yeah, these are our facts, Your Honor. Why didn't he just submit? You know, I've done hearings, not in a case like this for sure, but I've done hearings where we submit and we agree to waive the reading of the facts. And they might as well have done this, because we're not getting anything.
Can the court require the prosecution or defense to give the details?
Apparently not in Idaho. They have to have a finding of a factual basis for the plea. You can't just accept a plea. There has to be a basis in law of facts. And that's the purpose of this. But, in most cases, it's a reading of facts to fill every element of the crime. There's 4 or 5 different elements for almost any crime, for every crime. And there's just a reading of, enough facts, a reading of sufficient facts is what it's often called in different states, a reading of sufficient facts such that the court can have a finding of guilt. This is a lot of words. Some people would call it a word salad. This is a lot of words that just really largely fail to tell us anything new.
It's a lot of space fillers.
Yeah.
comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving.
I still hear that feedback. It'll go away. It'll go away. It's kind of annoying, but it'll hang with us. It'll go away.
Stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogen and Kaylee Goncalves.
So I guess something that's kind of new is the order. We didn't know the order before, but he talks about Kaylee and Madison, and so they were primary, and then Xana and Ethan are to come. So that little detail is new. Keep down in the comments. Keep telling us what you think is new and what we already knew from the BCA.
The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogen's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath.
It was touch DNA, and other jurisdictions have had cases where convictions were overturned for having been based in part only on touch DNA. But, you know, all that is water over the dam at this point, where Mr. Kohberger has admitted to having performed the crime. He's admitted his guilt in this plea agreement.
As well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Kernodle, still awake at this time, in fact, had taken a DoorDash order not long before this started. Her room was not on the third floor, it was on the second floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well.
That brings us back to the suspicion that Xana and Ethan just happened to be in the wrong place at the wrong time and they weren't targeted.
Yeah, that's what he seems to be saying. Yeah, I mean, if he went in, Mr. Kohberger did, and Madison and Kaylee were there, and then he encountered the other two. Yeah, I think you're right.
He didn't want any witnesses.
No. Yeah, so he didn't want any witnesses, so that begs the question, then why did he walk by Dylan Mortensen?
I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were two other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before.
And why did we never got an answer to the next question, which is obvious? Why did Dylan Mortensen wait 8 hours for anyone to call 911? I mean, really, that makes no sense. No answer.
Approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122.
So 4:20 he leaves. I mean, 15 minutes. How does he do everything in 15 minutes? I don't know. I will, in fact, recognized that if the man pled guilty, we have to take him at his word. The court conducted the requisite colloquy to make sure that it was freely and voluntarily entered. He hadn't taken any substance, prescription or otherwise. So, we have to acknowledge, I guess, that Mr. Kohberger has pled guilty, and so therefore he is guilty. But 15 minutes for, I have so many questions about, how does one person do all of this in 15 minutes? And, were there accomplices? Were other people involved? We don't have those details. And he's kind of dancing around some of that.
Do you think
Leaving
more
the
details
area.
will emerge if other people were involved after he becomes convicted?
Who knows? Who knows? And if Mr. Kohberger makes admissions down the road, who knows if he's credible? Would you believe anything the guy says after this? I wouldn't.
No.
And then the other question is, if you were one of the accomplices, you're certainly not going to come out and admit it, are you?
No.
So, there's just so many questions that we have all had these last 2 years, and they're not being answered here. I've never said that the purpose of this hearing was to answer all of the questions, but certainly some of the families are not happy that those questions aren't being answered. The biggest one is why? Why did he do it? What was the purpose? What was the motivation? What was the impetus to choose this house, these people, this time? One thing that has been said is, if he's so smart and he's a graduate student, he would know that Idaho's laws are pretty strict and they have a firing squad.
I think the families are left confused hearing him speak for the first time and hearing him just say yes over and over, admitting to it, but not getting the why out of him. I think that leaves them confused.
Leaves me confused too. It really does. Since this happened, Madison Mogen's parents have spoken through their attorney, and they say that they're satisfied, but certainly the Goncalveses aren't satisfied. And a lot of us who have been interested in the case for the last 2.5 years aren't really satisfied.
At a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town.
He almost lost control of the vehicles. I heard a psychologist who does another podcast, who's very interesting, say that he likened this whole thing to one of Ted Bundy's final rampages, where he went to the sorority house in Florida and just went into a rampage. And this psychologist said he just lost control to the point where when he was done in the sorority house, he went out and, found some other victims. And he likened Mr. Kohberger to Mr. Bundy, and that he was just out of control.
I've heard about that before, where it's like a blackout rage, kind of like you're blackout drunk and you forget the next day what happened.
Yeah, I think we've all known people that have had that. And if he went into such a rage and just went into almost an animalistic state, he almost lost control of the car, which, if you've just committed a huge, horrible, unbelievable crime, you don't want to call the attention to the cops. And, there are cops everywhere, especially in a college town. They had a football game that night. And so, he just wasn't thinking. People say, oh, well, he was a PhD in a criminology program. He was so smart. He just lost it. I'm not saying he was smart. I'm not saying he was stupid. I'm saying that he was almost in an animalistic, rage, and lost control to the point where he almost lost control of the vehicle. Really?
The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, Various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning.
He's looking for the knife sheath. Did I drop it on the way out? Where's my knife sheath? That's my take on it. I don't know.
It makes sense.
He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment.
How creepy if all of this is true, that he did this, he committed these crimes, and then he went home and took that selfie? Really? When it first came out, I thought, well, younger people take selfies all the time. Younger people, am I right?
Yeah.
People take selfies all the time, but I mean, yikes. At first I wrote it off, but I don't know. I don't know how that's relevant to guilt or innocence in this case. I really don't, but
I mean, it could be proving that he wasn't in his right mind if he just goes home and takes a selfie like a normal day.
I don't know. And other people have speculated. We don't know that he just wanted to show his parents, look, I got all dressed up and I go to church. I mean, I heard that. Now, it's speculation. Nobody knows.
With a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman.
Listen to this. Listen to this. I got something out of this.
And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River.
The Clearwater River and the Snake River. Now, why did Attorney Thompson, the prosecutor, go out of his way to mention those two waterways? Is he saying we don't know, but he might have thrown the knife in there? He might have disposed of the knife in there. The Snake River is very deep in some places. It has a lot of current in some places. And some people say, I don't know, but some people speculate that if he threw the knife in there, they'd never find it because of the current. Other people say, sure, with the technology that we have in 2025, send divers down there. But why did he slip that detail in about the Clearwater River and the Snake River? Why did he go out of his way and mention those?
Lewiston is Idaho's seaport. Large bodies of moving water down there.
Large bodies of moving water. Did they investigate? Did they send divers? Did they send metal detectors? I don't know.
In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the
Look at the judge. I think the judge is bored. Doesn't he look bored?
He looks bored.
13th, the state's evidence will show that following Sunday, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders.
To replace the one he used in the murders.
That there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred.
Can you really delete that stuff?
Later that
I don't know.
week, the state's
I don't think
evidence
so.
will show that Mr. Kohberger went to what we would call DMV.
I mean, I didn't hear you. I'm sorry. Can you delete that stuff on Amazon?
I don't think so.
It's in there. I mean, I guess even if you could delete a purchase of anything, maybe you're just deleting your display on your device, but Amazon would still have that record, wouldn't they?
Yeah, and even on my Amazon app, it'll be like, this item was delivered on this day, and it goes back like 6 months.
Oh, I know that. Yeah, I know, because I had bought some food for my poor dog when she was ill, and I had forgotten what it was, and I went to the vet, and he said, yeah, you should try that food again. She'll do better. So I forgot what it was, and I went back into Amazon, and I went way, way back, and I found it. And she likes it.
Motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate.
Now, when this fact first came out, I said to myself, wait a minute. You know, you can take that two ways. I mean, was it to escape detection because they might have had his license plate before the crime and then after the crime he changed it over? Or was it because, you know, when you move as a student to a new state, there are requirements in the new state that you register your car there within X number of days. And that was my first impression. I don't know.
It could be a coincidence. It could not be.
Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residents of the
No reasonable expectation of privacy in trash.
defendant's parents.
In other words, if you throw something in the trash, you can't later. There's actually a United States Supreme Court case on that. That if you throw something in the trash and then somebody comes along and grabs it, you have no reasonable expectation of privacy in your trash.
To the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, in public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally.
Imagine that, disassembled internally. I mean, Kohberger took the thing apart and got rid of all the DNA, really? Imagine that.
And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there.
Some degree of crud in there. I like that. Some degree of crud. This is the no crud prosecution.
We're spotless. The defendant's car had been meticulously cleaned inside.
Be careful. Always don't clean your car too much. They'll suspect you of something.
My car's a mess.
I have crud in my car.
The state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill.
Yeah, but a lot of crime students, I mean, how many people have gone through those programs? How many people have gone through Dr. Catherine Ramsland's program there at DeSales University back in Pennsylvania? And, you know, they've gone on to have successful careers in law enforcement, in teaching in schools, that kind of thing. So, that in and of itself, I kind of object to being used as a piece of evidence that he wrote. Well, he wrote a paper. I've written a lot of papers.
So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Madison Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle. Thank you.
Thank you.
Yeah, he did kind of break up there. He did kind of break down there. And, I have some sympathy for the guy. I know people like to ride the man, but I mean, it's a pretty awful thing. It's a pretty awful thing, and I can't blame the guy for breaking down there.
All right. Based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, first degree, as it relates to Madison Mogen, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to first degree for Kaylee Goncalves, how do you plead, guilty or not guilty?
Guilty.
As to count 4, Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than 1 full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
I really question the need to, from a legal point of view, to have a sentencing hearing on July 23rd. I think it's just to kind of not make the victims' families feel good, but just to assuage some of their contempt that they obviously have for Mr. Kohberger, and the contempt that they have, some of them, for the fact that the plea agreement was pretty much sprung on them at the last minute with his little opportunity for them to comment and to unload on Mr. Kohberger. Because I've seen some of have you seen some of these hearings before where people, they just really tell the perpetrator, how awful he is, what a horrible human being he is, that look what you did to my life. And that's all well and good. I'm not saying that they shouldn't do it, but it just seems like legally, I don't really think it has a whole lot of merit, because the judge is very likely, and I'd bet a cheap cup of coffee that, he's going to go along with the recommendation, 4 consecutive life sentences, plus another 10 years for the felony burglary and the $50,000 fines. I would bet that that's what's going to happen. So it just seems to me legally, substantively, there's no need for it. But, all right, I'll concede that the court wants to make sure that the victims' families get their day in court, and that's what it is.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties, or the next week, the week of August 4, is available.
Okay, so that's pretty much it. I mean, there was another couple of minutes where they talked about other things. They did schedule the thing for July 23rd, and they did. That gives the parties about an additional 2 weeks to get their act together, 3 weeks to get their act together. And the other thing was that the judge said, all right, Mr. Kohberger is now convicted. He's convicted of the crime, and so there's no need for him to have those street clothes. So that's the last time you're going to see him in a suit, in a shirt and a tie. He's not wearing a suit coat, but he's got a regular dress shirt and a tie, and so he is revoking his prior order that the defendant be seen in court in street clothes. So from now on, you're going to see him back in prison garb. So, those orange jumpsuits that they wear, that's likely what he's going to be wearing the next time. So that's really, substantively, what happened in that hearing. There's really no need to go through all the rest of it because it's pretty perfunctory stuff. And, I don't know. It's certainly earth-shattering that Mr. Kohberger, after all of these years, did plead guilty. It's certainly a major step in the case. Not a whole lot, that was new. What are your thoughts now that you've watched this whole hearing?
I think the hearing had like a very uneasy feeling to it. Almost as like there's more and like in the background that we don't know and that we might never know.
Yeah, there is an awful lot more. What was the motive? Why did he? I mean, even if he is, I'm not a psychologist. I've read enough true crime to be dangerous to know stuff about people's psyche. Is he a psychopath? Is he bipolar? We know that he did have a couple of diagnoses, which I don't know if they're really relevant to what happened here. We don't know why he picked these people. We don't know why. I mean, there's been all kinds of stuff out there. I mean, there was a rumor, and that's all it was, speculation, that maybe he picked them when he lived in Pennsylvania. Maybe he, all of the victims have active social media. Did he pick them when he was in Pennsylvania before he moved out there? Did he pick them once he got out there? Why did he pick them? Why did he have such contempt for them? Why did he do what he did with Madison and with Kaylee? What was the purpose behind it? How can you work into such a rage that you're driving the car out of control after something like this? What was the weapon? Certainly you go back to the very beginning, and the medical examiner said the wounds to each one of the victims was somewhat different. How long had he been planning this? Did he indeed stalk them? The probable cause affidavit asked that as a question at the top of one of the pages. Then it went off on, talking about the cell towers, and it never answered that question. In open court one day, yes, I know that Mr. Thompson acknowledged that there was no stalking. I don't believe anything that any of these people have said because so much has changed. And so I don't know. I really don't know whether there was stalking. But yeah, I agree with you that it was a really weird hearing. It was just to hear him say guilty, 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 guilty. And the whole tone of the thing was kind of odd, wasn't it?
It was. And I just hope like the families can accept that as some type of closure, even if they're not getting the full answers.
Well, we'll get some answers on the 23rd, but one of the questions that I heard being asked was, well, can Mr. Kohberger, who we see there in his, shirt and tie, can he speak at the hearing that's going to be held, the sentencing hearing? He can, but it's doubtful that he would. I'm going to guess that some of the families, I mean, you can only imagine the rage that they must have. And I'm going to guess that the families will try and goad him into saying something. How can you sit there quietly when you did this act and you've gone through the charade of, pleading not guilty, which is his constitutional right. And so I'm going to predict that at the hearing that's coming up, he will, in fact, remain silent. He has every right to, even though he is now a convict. He's no longer a suspect. He's a convict. He's been convicted. And so, it's his right, though, to continue to remain silent. Do you think he'll say anything at the hearing?
I don't think he'll say anything. I think there'll be a lot of tension in the room with everybody being around that he's just going to stay silent.
Yeah. I'm thinking that he probably has an obligation that he has to go to the hearing, but I don't know. What if he says he doesn't want to go? There was a case in New Hampshire where the defendant refused even to go to his trial, and that was unique. So why don't we take a look at what our viewers have to say?
Okay, a false star said, Mr. Myers, why in the hell would Bryan take this plea? I literally cannot make sense of this. This benefits no one, especially Bryan. This has to be one of the dumbest pleas of all times. With it being a death penalty case, even if he had a 1% chance of winning, why wouldn't you take that shot? Even if found guilty, he would have years and years of appeals, so I do not understand this at all.
Well, the answer to the question is only in Mr. Kohberger's mind. He's the only person that can answer that. I would have thought from a less psychological but more legal basis, why not? Why not go to trial? We attorneys call it a roll of the dice. We talk to the other side. We talk to opposing counsel all the time to see if there's any agreement. Can we reach an agreement? Because a trial is a major effort, especially a 3-month trial. I've never tried a case that went on for 3 months. I've tried cases that last a couple of weeks, and that's excruciating. But if we're not trying a case of this significance because the attorneys don't feel like it, that's wrong. That's terribly wrong. I can only guess, and it's only my thought, that he didn't want to take the chance of having to go before that firing squad in Idaho. I mean, I wouldn't. Who would want to? But
I say no matter how small the chances of winning, just take it anyway.
I would say so too. I mean, remember that the prosecution bears the burden. Even in a case like this, the prosecution bears the burden of proof beyond all reasonable doubt. So I'm guessing that the prosecution thought, hey, we don't have that strong of a case. It's all circumstantial. It is all circumstantial. So what? He drove around there. I mean, a good defense attorney can pick all of that apart, and a good defense attorney can make a good closing argument. So I would have thought from a legal point of view, why not there? Even if it's only a 1% chance of winning. I think that the chances would have been better. I hate when my clients ask me, what are the chances? Because it requires more of an analysis than that. But I would have thought that the chances of winning would be higher than 1%, maybe 5%. But yeah, it doesn't make any sense to me, Mr. False Star. It doesn't. There's more to this case than we see, though. So, Kaylee at Ivy, I am calling BS on this whole case. Something is off. That seems to be a prevailing sentiment. A lot of people think that it's off.
Grain of Sand 638. I understand the plea deal was in the works beginning of June. I don't think Bryan wanted to put his parents through court. After July 23rd, more information I believe will come out. I don't know 100% if he is guilty with such a circumstantial case, but I also don't think he would take a plea unless he was. This is so sad. My heart goes out to the families and friends of all these young lives taken way too soon.
Yeah. Yeah, good sentiment. Although I don't know if not wanting to put his parents through this would be the reason. I would think not wanting to put, Kaylee, Madison, Ethan, and Xana's parents through this would be more of a thing, but not if he did what he did. And now we know that he did because he said that he was guilty. I mean, apparently he doesn't really care. He has the psyche of someone, apparently, from what we know. No, I don't know him. I know our commenter is going to say, well, you don't know him. You haven't met him. You haven't made a clinical diagnosis. I know all of that, but I know what I read and I hear and I see, and it doesn't seem like he's somebody who would really give a wild you-know-what about the parents. Number 2, I hear music. I hope that's all you hear. You know what's missing from this plea deal, something only the killer would know. Yeah. Yep. We don't know a lot of stuff, and we talked about that earlier in this episode.
Number 1, D-Tart 2025. I just don't understand why they waited so long to call 911. Me either. One of
No.
the girls saw a scary guy wearing a balaclava with bushy eyebrows. I would have called 911.
So many unanswered questions in this case, and that's one of them. It's a primary one. What went on? The prosecution's story about that has changed over the years, and it's a mystery. And whether we'll ever know, we don't know, because as I said before in this episode, who knows if Mr. Kohberger will tell the truth about his side of it, and who knows if these two girls. I think Dylan and Bethany, if anybody wins anything out of this whole thing, they're the winners, because they don't have to go to court. We know that Bethany didn't even want to go to the preliminary hearing. She fought tooth and nail. Dylan has been through what she's been through. People have derided me in the comments. How can you make comments about this? Well, I have made comments over the years about, why they waited all that time, 8 hours, and what was their state of mind. And she could have been cross-examined very heavily on the fact that, she admits she was drunk. She admits that she didn't know if it was real or not. But these two young ladies that you're looking at now, it's imagine the weight that's lifted off of their shoulders right now. That, I wonder, A, if either of them will make a statement now, and B, if they do, if it's believable. So yeah, comment down below. Let me know what you think. And the last thing we always do in episodes on the Idaho 4 say that, yes, it is about the 4 young people and their families. And we do have a lot of strong feelings and sympathy for the families of Xana Kernodle, Madison Mogen, Kaylee Goncalves, and also Ethan Chapin, because, what a horrible, horrible thing to say. So, Kelsey, what are your closing thoughts?
I'm just hoping that at the sentencing hearing, we get some type of answers out of him. And I'm hoping he doesn't stay silent and that he will show up and speak up.
Me too. My same closing thoughts. I have a feeling that we'll be talking about this case for a long time. I have a feeling that we'll be hearing more from all the people. The one thing that I clipped at the end of the hearing was the judge asked the attorneys if they would agree to get rid of the gag order, the non-dissemination order at this point. And they both said, no, let's wait until after the sentencing hearing. So the onerous, non-dissemination order that has been suppressing what's happening in this case for the last 2.5 years, that will very likely almost positively be lifted on July 23rd or whenever the final hearing is held. So who knows? Who knows what we'll hear? Who will be lining up behind the microphones outside the courthouse or calling into whatever source they want to talk to, and who knows what we will hear. So stay with us. There's a lot more. We'll hear a lot, whether it's true or not. We'll hear a lot about this case. Please, if you've enjoyed this or if you want more, let us know down in the comments what you think, what you want us to cover, what you think really, really, really happened that night. Please be sure to subscribe, like, and share. And we hope you have enjoyed this episode, and have a good one. Whether you're in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
Always some degree of crud.
Guilty. Guilty.